advocates, very senior counsel, the file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before it. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship,
My Lord, if I may, my Lord. There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Your Lordship.
Okay, you have
The
talked enough.
council on this side be heard.
Yes,
Council on that side appears to be taking the whole of it.
because they stand back.
Please just speak, Mr. Mute. If you want to be heard, just speak. We
My
listen.
lord, I'm asking
Yes.
of equity of land.
We-
Accord time to council on this side.
They stand and
Address
speak.
the-
You also just stand and speak. We have
Yes,
not
Your
stand
Lordship,
and speak.
my lord.
Yes.
My lord, I think for purposes of clarity, yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling we read, the question that we wanted was the application for the validity, plus the issue to do with the recusal we had together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the 3 pending, I should know about it, 3 applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number 1. Issue number 2, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my lord is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim, and I reiterate that. For purposes of the petitions before you, we would like this petition had as of yesterday. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitution, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number 1. Issue number 2, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Ms. Kimotho, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situations where some of the advocates in the 4 matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my Lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My Lord, I beg you to have the
Your Lordship, that I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. I said,
Your Lordship,
we will talk about that.
Your Lordship,
I will talk about that notice before you speak.
My Lord,